Morning, Mr. Jordy.
Morning, sir, Your Honor. I'd first like to say that I am here. I am Darren Allen Jordy, the living man. And I would also like everything on and for the record, sir. And I would like transcripts of that. I would like to reserve all my rights. I am here by special appearance and summons and duress of warrant. And I am here to also challenge the jurisdiction of the court respectfully.
Okay.
I have filed a motion with the clerk already this morning. You have copies for the district attorney.
Have the people received a copy of that motion?
We have, Your Honor. I do believe one was filed into the case file, but we have just...
I would also like to say on and for the record that the civil matter already being handled in Denver County. I've provided a case number for that as well.
All right, a handful of initial issues. The court has had an opportunity to review the pleading that was filed by Mr. Jordy earlier this morning. That's a motion to dismiss challenge for or of jurisdiction. And a couple of the issues you brought up initially, Mr. Jordy, first with respect to the record of these proceedings, everything that is said in this courtroom is being recorded, and that's being recorded on this FTR machine over here.
Thank you.
If you would like transcripts of this proceeding or any other proceeding in relation to this case,
Yes.
you are welcome to request those transcripts, and you can obtain a copy of the transcript of this proceeding and any future proceedings through the request.
From the clerk's office.
Correct.
Yep. Understand.
So with respect to the record and the transcripts issues that you raised, those can be requested, as I mentioned a moment ago. You are on a summons in this case, and the summons required an appearance this morning. The summons will be continued through the duration of the case, and so ultimately you'll remain on that summons as long as you continue to appear for any future court settings. If you fail to appear, then the summons could be revoked and the court could issue a bench warrant for your arrest. But for today, you are in fact on that summons. With respect to the nature of this proceeding, this is not a civil case. This is a criminal case. I see that Denver case 25 CV 33908 appears to involve you as a defendant in a civil matter in Denver. Looks like Long Building Tech Inc. versus Jordy Mechanical Inc.
Correct.
And so to the extent that that civil case relates to the same allegations that underlie the criminal case, that would be a collateral matter in civil court, whereas this is a criminal case.
I completely understand that. I would also like to point out to the court that these checks that are in question here in the criminal case, they were transferred on the property of 59.
The hearing begins with Darren Allen Jordy immediately taking an unusual approach. Instead of simply answering the court's questions, he introduces himself as a living man and starts reserving his rights while challenging the court's jurisdiction. He also informs the judge that he has already filed a motion. Right from the opening moments, it becomes clear that this hearing is going to focus heavily on legal arguments rather than a straightforward arraignment.
Alleges fraud by check, which is a class 3 felony, and we'll talk about the offense in a moment. Are the people alleging that the fraud or some part of this this culpable act occurred in the state of Colorado and county of Arapahoe?
We are, Your Honor.
Okay. And so the people are alleging, Mr. Jordy, that the offense occurred at least in part within the state or state of Colorado and county of Arapahoe. And so that is the basis for this court's jurisdiction. This is a criminal court in Arapahoe County, and the people have filed a single count alleging that a crime occurred in part in Arapahoe County. And so with respect to jurisdiction, that is a basis under the law to potentially transfer a case to the court that does have jurisdiction. It's not a basis, however, to dismiss a criminal case. And so with respect to your motion this morning to dismiss for lack of jurisdiction, I don't see anything in terms of the law or argument in that motion that would suggest that this court lacks jurisdiction under the circumstances. If you would like to file a pleading noting the basis upon which you believe the court is deprived of jurisdiction and that it should lie elsewhere, then you can file a motion to transfer the case, but that would be the relief that's available under the law under those circumstances.
The Constitution of the United States under Article 3, Section 2 states that any time that the state is a party against a citizen of that state, the Supreme Court has original jurisdiction.
The United States Supreme Court?
it says the Supreme Court has original jurisdiction.
Okay. Well, the 10th Amendment of the United States Constitution notes that all rights not specifically reserved to the federal government are essentially within the purview of the states. And that's what's essentially occurred here. The state of Colorado has passed a statute that has criminalized the offense in question, fraud by check. And so that's the basis of this court's jurisdiction, and obviously the people of the state of Colorado filing accounts accordingly. And so the court is finding jurisdiction this morning. I don't see any of the argument or law in your motion that would suggest otherwise. And so that will be the court's finding this morning. If you have additional argument or law you want to cite, you're welcome to do so. And so with respect to the initial documents that we need to address, Mr. Taylor, did you have a mandatory protection order, Rule 5 advisement?
The defendant was unwilling to sign them when I provided them to him.
Right.
He said he wanted to be advised by the court first.
All right. And so, Mr. Taylor, I'll ask you to approach with those documents and I'll talk through those with Mr. Jordy.
Sure, absolutely.
All right. So, Mr. Jordy, I'm going to advise you as to your rights pursuant to.
Jordy's main argument is that the court does not have jurisdiction over his criminal case. He references constitutional provisions and attempts to explain why he believes the matter should not be handled in this courtroom. The judge, however, carefully explains that the alleged offense occurred, at least in part, within Colorado and Arapahoe County. According to the court, that provides a legal basis for the court's jurisdiction.
And if you cannot afford an attorney and you are considered indigent based on state guidelines, you may request that an attorney be appointed to represent you. If the public defender is appointed to represent you while you are in custody, which is obviously not the case here, and then you are released from custody, you must then travel to the public defender's office and reapply if you wish to continue to have such representation. Because you were never in custody in the first place in this case, you would need to apply out of custody if you wish to have a public defender. The district attorney represents the state of Colorado and does not represent you. The district attorney cannot give you legal advice. In most cases, you have the right to have a reasonable bail set. We may discuss bail today when your case is called. And if you are a defendant on a Victim's Bill of Rights case, otherwise known as the Victims' Rights Act, and bond has already been set by schedule or on a warrant, the bail cannot be discussed until the court can find compliance with the Victims' Rights Act. If this applies to you, your case would be set over expeditiously on the issue of bond to allow for compliance. And so again, sir, you are on a summons in this case. We won't be addressing the issue of bond this morning. And I'll just note for the record that this case does not involve a Victims' Rights Act offense. You have the right to a speedy and public jury trial, or if the district attorney agrees, a trial to the court. You are presumed innocent, and if you plead not guilty, you have the right to require the district attorney to prove your guilt beyond a reasonable doubt. At trial, you have the right to cross-examine witnesses, to testify on your own behalf, and the right to subpoena witnesses to testify on your behalf. You also have the right to appeal any rulings or decisions in the event of a conviction, and if you are charged with a petty offense, which is not the case here, you are entitled to a jury if, within 21 days after the entry of a plea of not guilty, you make a request to the court for a jury trial in writing and tender to the court a jury fee of $25 unless the fee is waived by the court because you are indigent. If you are alleged to have violated any law pursuant to Title 18 of the Colorado Revised Statutes, which is the case here, the law requires that a mandatory protection order will enter against you, and I'll talk to you about the terms of that order in just a moment. The protection order will state that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are charged with committing, and other conditions may be ordered by the court as part of the protection order as well. Compliance with the protection order will be mandatory and could be the basis of contempt proceedings or new charges filed against you, which may be a misdemeanor or a felony. You may be able to resolve your case by plea agreement, but please keep in mind that any plea of guilty which you may enter must be a voluntary plea and not the result of any threats, coercion, or undue influence on the part of anyone. Any agreements you make with the district attorney must be.
The judge then makes an important distinction. If Jordy believes the case belongs in another court, the appropriate legal procedure could involve requesting a transfer rather than demanding that the criminal case simply be dismissed. After reviewing his motion, the judge finds that it does not establish that the court completely lacks jurisdiction. His first major legal challenge, therefore, fails to produce the dismissal he was seeking,
such as motions, trial, appearance of counsel, or some other setting. And so based on that advisement, do you have any questions for me about any of those things we discussed?
The only thing I would have a question on right now is I have the right to indictment, correct?
The right to indictment?
Yes, not by trial by information.
No. So the people are permitted to proceed by complaint and information. That's how they proceeded in this case. And so there's no grand jury indictment. That's one of the ways that people can seek criminal charges. But they can also file criminal charges based on a statement of probable cause and a finding of probable cause by a judge, which is what ultimately this is a summons case. And so no court has found probable cause, and you're not in custody this morning. But the people are proceeding by complaint and information based on the fact that this is a summons case. So there's no right to a grand jury indictment.
I'm sorry, and I mean no disrespect, but I do not understand that, but I will, I don't know what to say after that.
Well, I can't give you legal advice here. Obviously, if you'd like to seek legal advice, you're welcome to retain counsel, and we'll talk about that in just a moment. But in this case, the people have simply filed a complaint and information, as I mentioned a moment ago, that charges that one offense. I'll talk to you about the nature of that offense in just a moment.
Sure.
But in terms of the Rule 5 advisement that I just read, the rights that you have, do you have any additional questions about any of that?
No, sir.
All right. And sir, have you ever served in the U.S. Armed Forces, or are you a veteran?
No, sir.
All right, I'm going to mark the form no, and I'm going to stamp this as reviewed with and acknowledged by Mr. Jordy on the record today.
Thank you, sir.
Of course. Mr. Jordy, the next document we need to talk about is this mandatory protection order. I alluded to this a moment ago, and this order will enter in your case this morning. The order will name you as the restrained person. It will name Michelle Van Shiver as the protected person. The order does not involve a crime of domestic violence or a Victims' Rights Act offense, and it will contain a handful of terms. First, that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are accused of committing. Second, you will vacate the home of the victims and witnesses and stay away from any location they are likely to be found. And third, you will not contact or have direct or indirect communication with the victims or witnesses. Finally, you will be restrained from the location of 5001 South Zuni Street in Littleton, Colorado. And those will be the terms of the protection order. Do you understand each of those terms?
Yes, sir. And with the exception that I don't even know who that is.
Okay. Well, if you happen to run into this person understanding that fact, then you should just...
Before Jordy continues discussing the case, the judge gives him a crucial warning. Everything said inside the courtroom is being recorded, and prosecutors can potentially obtain transcripts of the proceedings. The judge therefore cautions him against discussing the actual facts of his case. This becomes an important moment because Jordy appears eager to explain his position, while the judge is trying to prevent him from making statements that could potentially be used against him later.
This is the one-count complaint and information that was filed in your case. We also discussed this a moment ago. The single count charged against you is a Class 3 felony, and the allegation is fraud by check with a value of between $100,000 and $1 million. So that penalty, the maximum penalty for that particular offense is 4 to 12 years in the Department of Corrections. It also carries a maximum fine of $750,000 and 5 years of mandatory parole. That count alleges that between and including September 19th and November 15th of last year, 2025, you, Mr. Jordy, knowing that you had insufficient funds with the drawee, U.S. Bank, with intent to defraud, unlawfully issued 2 or more checks within a 60-day period, totaling $100,000 or more, but less than $1 million in the aggregate, to Long Building Technologies for the payment of an HVAC unit. So that is the single count that's been charged against you. Do you understand the general nature of what you're accused of in that count?
Yes, sir.
Do you have any questions?
No, sir.
All right. So this count is a Class 3 felony. It will be eligible for a preliminary hearing in this division, even though you're out of custody. So your case is going to remain here in this division for now. Do you have a plan for an attorney? Do you intend to apply for a public defender or hire private counsel?
Sure, I will hire counsel at this point.
Okay. And do you have anyone in mind at this stage?
No.
Okay. So what we'll do is we will set you for an appearance of counsel about a month down the road. We'll give you some time to retain counsel. Please make sure you stay on top of that issue between now and the next court date. And when you come back about a month from now, we will check back in on the status of that, and hopefully you'll appear alongside your attorney on that next court date as well. Any additional questions from me at this stage?
I don't think so, sir.
All right. Anything from the people on this case?
No, Your Honor. Thank you.
All right. A good date for appearance of counsel in Division 302, please.
We'll set July 23rd, 8:30 a.m., Division 302.
All right. Mr. Jordy, would you like a setting slip with that next court date on it?
Yes, please, sir.
That's coming out to you now. Do we have a fingerprint order in this case as well?
Yes.
Thank you.
Can you grab this?
Is there anything just sign? Okay. Thank you, ma'am. All right.
The court then moves through Jordy's formal rights. He is told that he has the right to remain silent, the right to an attorney, the right to a trial, and the right to require the prosecution to prove the allegations beyond a reasonable doubt. The judge also explains that he is facing a Class 3 felony allegation involving fraud by check, with the alleged checks totaling between $100,000 and $1 million. The potential consequences described by the court are extremely serious.
Proceed. Do you understand your rights?
Yes, ma'am.
Very good. You've already had a chance to speak with Ms. Ikiriak and Ruli today, correct?
Yes, I did.
All right. And so she will continue to assist you today. I am going to now sign the referral to the local appointing authority, and they will, of course, be in touch with you. Do you have a conflict with them?
Yes, there is a conflict, but like I told her, just to get everything resolved today as much as possible, I'll waive the conflict as of today.
Okay. Well, for today, the conflict, we're not concerned with the conflict today because today is just your arraignment. So they have a special process they follow, so they'll get you somebody else to represent you if they find there is a conflict, and that happens pretty quickly. But thank you, sir. All right, we'll proceed with appearances by counsel. We will start with Ms. Reiser.
Patricia Reiser on behalf of the people.
Assistant Public Defender Chinazi Kiriakin-Ruli on behalf of Mr. Jeremy Shue.
Thank you. Ms. Ikiriakin-Ruli, would you like me to read the complaint in this matter, or do you waive formal reading?
Your Honor, we do waive formal reading. I've had an opportunity to review it with Mr. Shue. He stands mute, asking the court to enter a not guilty plea on his behalf.
Thank you. So the court will not go through the details of the complaint with you, Mr. Shue, because you've had a chance to review that information with counsel. We will, based upon you standing mute, enter a plea of not guilty for you. We will schedule you for your next court date. That is going to be a pre-trial. That will be with your assigned judge October 28th at 9 a.m. That's going to be Judge Washington at 14B. Her hearings at this point are by Zoom.
Yep.
We'll get you a notice to appear, and then you'll receive additional information from the public defender's office. You understand?
Yes, ma'am, I do.
Very good. Last thing we need to address in this matter is bond. There are two parts to bond conditions. Those are things the court tells you you can and cannot do. If you violate a bond condition, you're subject to immediate arrest. The other side of bond is whether you can be released today on your own or whether you'd have to post a bond. Before I make any decisions regarding bond or bond conditions, I will hear from counsel. We will hear from the people first.
Thank you, Your Honor. I noticed in the bond recommendation form, it says PR with backup of $10,000. I am actually asking for a cash surety bond of $10,000.
The hearing then turns to a mandatory protection order. Jordy is ordered not to harass, intimidate, retaliate against, or contact the protected person or witnesses. He is also instructed to stay away from certain locations. When Jordy says he does not even know who the protected person is, the judge makes the instruction very simple. If he unexpectedly encounters that person, he should turn around, walk away, and avoid any communication.
There are so many offenses here, I can't even list them all. So in addition to that, I will say that
I'm going to stop you for a second. Mr. Shue, number one, you have counsel. So if there's any objections, she's going to do the objecting. Okay. Number two, these are bond arguments. And so your counsel is going to have an opportunity to speak, as you know. So please, no interruptions. I don't want to have to mute you, but I will if I have to.
No problem, ma'am. I'm sorry.
Thank you. All right, Ms. Reiser, I am sorry. You're welcome to proceed.
Thank you. And additionally, I've spoken with a deputy from the sheriff's office. My understanding is there is an ongoing investigation. In this case, it's likely the defendant will be charged with possibly, among other things, breaking and entering of a building. Right now, based on the investigation thus far, as the court is aware, he's charged with receiving and concealing stolen property. In short, I am concerned about the community and safety of the community and the right of people to be safe and secure in their property and their belongings. Mr. Shue represents a threat to all of that. So I am asking for at least some cash bond I'm asking for all standard bond conditions, including no go-to, the address listed. And if the court is not inclined to order a cash bond, I think a tether would likely be appropriate to make sure that he stays away. Just to summarize, I'm concerned. This person has an extensive criminal history. I'm concerned about that additional offenses will be perpetrated and that people will have additional belongings stolen, buildings, or whatever of the myriad crimes that he has a history of doing. And so I would ask the court to take all of that into consideration and when deciding on the bond. Thank you.
Please rise. The address listed in the complaint, that's a private residence, is that correct?
Yes, Your Honor.
Okay. And in your paperwork, do you have a name of the owner of that property? Is that something that you can submit to the reporter?
Yes, I can find that and submit that.
Thank you.
The judge next asks Jordy about legal representation. Jordy says that he intends to hire a private attorney, but does not yet have anyone selected. The court gives him additional time to find counsel and schedules another appearance. The judge emphasizes that Jordy needs to stay on top of the situation and return to court with an update about his attorney.
Give me 1 second, Your Honor.
Mr. Shu, do you have other bonds right now? Are you being held on other things?
No, I'm not. This is the only thing, and this is a misdemeanor.
I'm not asking you to make bond arguments. I'm just asking you that one question. Are you being held on anything else?
No, ma'am. This is it.
Thank you.
Your Honor, I had an opportunity to speak with Mr. Shu. He reports that since his last case closed out, he's not on probation, not on bond for anything. He said that he's been doing extremely well. I think it's been about 10 months now, Mr. Shu, since your last case was closed out. He says he's been working, he's been doing construction. He was scheduled to actually go to North Carolina to help with the hurricanes in a few days. I don't know. I don't think he has a date set for when he was to be going, but he's been trying to balance that with taking care of his mother. His mother lives in Belleville, whom he lives with. She's currently has a broken hip, and he has been doing a great deal of caregiving for her as she recovers from that particular injury. I don't want to speak too much about the accusations here, Your Honor, but I'm hopeful that the court will be able to balance the, I respect or I understand, appreciate the people's recitation of Mr. Shu's criminal history. I think that's something that the court is aware of as you have access to all of that information. However, Your Honor, he's paid his penance for all of those things. He's served whatever time was necessary or placed on him by the courts. And since he has been released, he has been doing fairly well. If there aren't any additional charges that have been brought forth with what we have before us today, I'm asking that the court offer Mr. Shu a PR bond. He is familiar with the court system. He knows the penalties of not coming to court. He knows the penalties of not abiding by bond conditions. And based on our conversation, he is ready and prepared to abide by those bond conditions. He denies these accusations. Again, I don't want to go into details about the facts of the case. However, he does fully intend on disputing them, and he indicates that he has information that will hopefully be able to absolve him of these charges.
Thank you. I hesitate to ask this question, but I'm going to do it anyway, and I'm hoping that...
Later in the proceedings, the focus shifts to another defendant, Mr. Shu. The prosecution argues for a $10,000 cash bond, pointing to what it describes as an extensive criminal history and an ongoing investigation that could potentially lead to additional charges. The defense takes the opposite position, emphasizing Shu's recent employment, family responsibilities, and claim that he's been doing well since his previous case. The judge now has to weigh public safety concerns against the defense's request for release.
Light down the road, and that was the first information that I was informed of this case.
Okay, thank you. All right, and I received the names of the individuals as well. Thank you. All right, I'm going to set the following conditions for you. It's important you understand your conditions so you can stay in compliance with your conditions. You'll get a copy of these when we are done. No alcohol, no illegal drugs, and no marijuana. Do you understand?
Yes, ma'am, I do.
Do you have a medical marijuana card?
No, I do not.
Thank you. You'll be required to do standard supervision at our community corrections department to ensure that you're staying in compliance with that condition. Failure to appear is going to result in a warrant for your arrest. Do you understand?
I do, ma'am.
You'll have to get to community corrections on the next business day after you have been released. You'll need photo ID and $12. If you don't have photo ID, you can ask the jail for a copy of your booking photos. You're not allowed to leave the state of Michigan without prior permission of the court. Did you have travel dates to go down?
No, I did not, ma'am.
Okay, so after I'm done with your case today, if you intend to travel outside of the state of Michigan, then you'll have to make that request of Judge Washington. She will be your assigned judge. Do you understand?
Yes, I do, ma'am.
You are not to have any assaultive behavior towards anyone. You are not to go to the address in question, 7 Whitaker Road, that is in Ypsilanti Township. There's no reason you'd have to go to that address, is there?
No, ma'am.
You are to have no contact with, when I say no contact, no direct or indirect contact with either of those individuals in person or through others. No telephone, email, texting, internet, or social media. Don't direct anyone else to be in touch with them on your behalf. Do you understand?
Yes, ma'am. I don't know them anyways, so yes, I understand.
Okay, it was just a yes or a no.
I'm sorry.
You are not to send them anything or mail them anything or have anyone deliver anything to them, and everything you are barred from doing, you can't direct another person to do on your behalf. Do you understand?
Yes, ma'am.
You're not to violate any criminal law. You're required to appear for all of your court hearings and other places as directed by the court. All your conditions, they will exist whether you're in custody or out of custody.
As the bond hearing comes to an end, the judge lays out strict conditions that Shu must follow, including restrictions involving drugs, travel, contact with certain people, and court appearances. The judge ultimately sets a $10,000 backup cash bond and makes it clear that violating the conditions or failing to appear could trigger serious consequences. In one of the strongest moments of the hearing, the judge even warns Shu to stop talking because additional statements could potentially change the court's decision.
I have to take that into consideration as well. You have a really long criminal history, and I know that you know that. And I'm not telling you anything new by telling you that. And you and I have dealt with each other in the past on prior cases. It looks like this matter is still being investigated, and there is a suggestion that additional charges may arise. This type of charge is kind of a similar charge to what I find on your criminal history. So that causes the court to pause about whether you are a danger to the community. I know in the past there have been some failure to appears, but in general, you get to court when you are supposed to get to court. So really it's a question of protecting the community. You're living in Belleville with your mom, is that right?
Yes, ma'am.
And is there any reason you'd have to be in the Ypsi Township area?
No, not as of now, other than to visit my father, as far as that's the city of Ypsi. Nowhere near where I guess the victim's residence or whatever it is.
And are you working?
Yes, I am. I'm working construction with my father and my little brother. That was when I was arrested riding a bicycle, but for some reason they impounded my truck after the arrest or during the arrest. So I got to deal with trying to get my work truck out, which is my father's work truck.
Okay. So again, I try to ask kind of specific questions. How many hours a week do you work?
It's like I was telling community corrections is basically job to job, depending on what type of construction. Sometimes it's 40, sometimes it's 5, depending on what we have going on at the time.
And it released you on your own personal recognizance. I'm going to set a backup cash bond of $10,000. If you fail to come to court when you are supposed to or violate any of my conditions, that's the minimum bond that you are going to face is going to be $10,000. Do you understand?
Yes, ma'am.
I'm really hesitating on this one because of your history. It's really hard for me to do this. Please don't. I'm just going to stop there. And I encourage you not to say anything at this point, because if you say other things, you may actually change my mind. Anything further we need to address, Ms. Akiriak and Rulli?
Nothing from defense, Your Honor.
Okay. Ms. Weiser, anything further?